Hello to all of you. My name is Rahul Donde. I am the Global Events Director of Young ICCA, and along with Dominic Notage, Young ICCA's co-chair, Masaki Kawasaki, Young ICCA's Events Director, and the invaluable assistance of a large number of CIETAC representatives, I am very pleased to welcome you today to this webinar. I will be making a few introductory remarks about Young ICCA, introducing you to Young ICCA, and then Mr. Brad Wang will make a few remarks, a few introductory remarks concerning CIETAC, and a few other young CIETAC representatives will be making their remarks as well. We hope this seminar is educative and informative. But before we get into really the substance of the webinar, just a few introductory remarks from me about Young ICCA. As many of you may be aware, Young ICCA is an arbitration association that is interested in and that promotes international arbitration amongst the global arbitration community, particularly amongst younger arbitration practitioners. We are one of the largest young arbitration associations in the world today, with over 8,500 members spread across the world. This year, we celebrate our 10th anniversary, and we look forward to spreading the word of international arbitration in the years to come. Young ICCA itself is organized along 4 axes. There are 4 main verticals that we participate in. The first is webinars and workshops like the current one. The second is scholarships. We offer a large number of scholarships. Details are available on our website. Third, we have a Young ICCA blog where we publish articles and short pieces on topics of current relevance and importance. And finally, we have a mentorship program. These are the four main platforms on the basis of which Young ICCA is built. We have a large amount of information about each of these 4 platforms available on the Young ICCA website. And for those of you that are not yet Young ICCA members, I would strongly encourage you to check the Young ICCA website and consider taking up membership. All of us are of course available to answer any questions that you may have. Feel free to approach us offline in the event you would like us to give you further information about any one of our projects or endeavors. That's all from me right now. I turn the floor over to Mr. Brad Wang of CIETAC. Thank you very much.
Thank you, Rahul. Ladies and gentlemen, I only at this stage have one more thing for the housekeeping. The following welcome remark will be delivered by Mr. Wang Chenjie of CIETAC, who will be using Chinese Mandarin. For those who need assistance in translation, please click the interpretation button on the Zoom so you can switch the channel to English. And for those who would like to hear the following seminar in Chinese, you can choose Chinese. We have simultaneous translation provided throughout the whole seminar. And without further ado, let's welcome Vice Chairman and Secretary General of CIETAC, Mr. Wang Chenjie, for the opening remarks and the welcome remarks as well. 女士们、先生们，下面我们就会有请冒重。
Now we're going to have Mr. Wang Chenjie, Secretary General and Vice Chairman of the CIETAC, to address us openly speaker. If you need a translation service, please click the button indicating the translation into the English or Chinese language channel. We provide interpreting service throughout the channel, throughout the event. Ladies and gentlemen, it's welcome, Mr. Wang Chenjie. Young practitioners from Young ICCA around the world, the honor coaches and participants of 18th CIETAC Cup, dear friends, good and you, good morning, good afternoon, and good evening. Thank you all coming from all times around the world on internet to participate in the first webinar jointly presented by CIETAC and Young ICCA. Our event is also part of the 18th CIETAC Cup series. This means that our event is opening this series events. We focus on the opening and the closing arguments in the tribunal of arbitration and how tips and preparation could be done. It's very timely for a young practitioner to learn. It's also a good opportunity for the experienced arbitrators and attorneys to discuss or share experience. Looking forward to the presentations and sharing of the speakers. On behalf of CIETAC, I'd like to extend my warmest on gratitude to the success. I would like to thank Young ICCA and CIETAC. We also hope that the members of Young ICCA can also exchange more with the CIETAC. Young ICCA is a young practitioner organization under ICCA. The CIETAC relationship with the ICCA can date back to the 23rd of June 1994, when we first presented the International Arbitration Congress in Beijing. That meeting was very influential for the promulgation of China arbitration law. After that, in 2004, the 17th ICCA conference was again held to China. Back then, we had participants from 5 continents, 47 countries and regions, 300 international experts for the conference. Many important arbitration institutions will send their representatives to the meeting. Back then, that was the most successful arbitration event. 16 years on, now, CIETAC is ready and able to present more with you in the near future for closer cooperation with ICCA at different levels. Upon inception in 1956, CIETAC is an international brand of China arbitration, which has been dedicated to exploring and developing China experience in arbitration. Let's look at 2019. We accepted on 3,333 cases from 72 jurisdictions. Many of them are non-Chinese parties. These are international cases. Claim amount reached 122 billion RMB, reached world number 2. It was exceeding 100 million amount to 221 cases. This means we're able to handle major, serious, and complex cases. It's on demonstration that CIETAC is the stage where you can demonstrate your talents for those who have ambition, both speakers and practitioners. In 2020, as we are still undergoing the pandemic of COVID, this new challenge for arbitration, we took measures as a response. We completed online filing and a tribunal hearing. We also established smart tribunal. We also established a video code of the tribunal, whether no matter where you are at home, you can simply go through such service, online filing, tribunal hearing, and procedures of arbitration. With these measures, we can ensure that arbitration can go on amid COVID-19. In the first 9 months of the year, we accepted 2,968 cases. Year-on-year growth was 11.77%. Out of them, related cases amount to 577. Year-on-year growth at 25.7%. Parties are from 70 jurisdictions. The cases are more international. In 2012, we established Hong Kong branch CIETAC Hong Kong Arbitration Center. Versus 2019, the caseload of 2020 of Arbitration Center in Hong Kong increased by 166.7%. They are all cross-border disputes. Half of them are conducted in English. Hong Kong Arbitration Center uses the common law, procedural law to administer cases in Hong Kong. A global internship plan has recruited almost 20 countries on alumni of law to practice in Hong Kong. We also help them to practice in first-level courts, law firms, and schools of law for work. This is exemplary and also an interaction point for young practitioners around the world who are interested in arbitration. As for the topic of young practitioners, CIETAC is dedicated to developing and nurturing the young force of international arbitration. Our club competition was held many years ago. We have accepted over 200 schools of law, 4,000 students altogether to enter for the competition, with introducing the Weissmut with a practice and a mock. We promoted this mechanism of arbitration resolution. We have increased literacy of the law and also the capabilities in arbitration. I accepted the 61 teams to demonstrate their traits, demonstrate their levels, and I also hope that you can also demonstrate your talents in the international arbitration stage. At the same time, I would like again to invite more Chinese international universities to take part in our CIETAC Cup. We also hope that lawyers of Young Cup can also enter for our event as coaches or arbitrators so that you can work with the Chinese arbitrators, lawyers, students, and teachers for closer relationship or connection. To conclude, I'd like to thank the participation of speakers again. I also wish our webinar every success. Wish you everything well. Happy family.
感谢王秘书长。Masaki,
Thank you, Mr. Wang.
to the presentation session. The floor is yours.
Thank you very much, Brad. Hello, everyone. My name is Masaki Kawasaki, Yangika Events Coordinator. Without further ado, I would like to move on to the first main topics of this webinar. We will have two presentations, approximately 10 minutes each, on tips and tricks regarding written and oral advocacy. These will be given by two senior and distinguished arbitration practitioners. Mr. Mahesh Rai, Deputy Head of Construction and Engineering Practice and Director of Dispute Resolution Practice at Drew and Napier LLC, and Ms. Fan Tao, partner of Huichong Law Firm, if I have pronounced correctly. We are very excited to have them both with us today. In the interest of time, I'm not going to read aloud their biography, but you can find the details of their professional background and vast experiences on their respective firms' website, as well as the registration page of this webinar. I will now hand over to Mahesh, who will give us the first presentation on written advocacy. Mahesh, now the floor is yours.
Thank you, Masaki. Good evening, everyone. And let me just say it's my pleasure and honor to be here and to talk to you about some top tips and tricks relating to written advocacy. Now, as a matter of general application, the purpose of written advocacy is to frame the issues in a way that is to your client's advantage. It is often an opportunity that is overlooked. It's an opportunity that is a golden one because it allows you to impress the tribunal and to leave a lasting impression about your case, even when the flair and gusto of oral advocacy fades away many months after the oral hearing or cross-examination. The purpose of written advocacy, much like oral advocacy, is to persuade. It is not to confound, it's not to confuse, it's not to agitate. Arbitration cases are very complex in their own regard. So if you present your submissions in a simple, clear manner that elucidates and enlightens, you will often find that the tribunal will end up using your submissions as a basis for their written award. Now, that I'm going to go through 5 quick points in the interest of time, relating to written advocacy. The first point relates to using structure and headings to argue your case. Now, what do I mean by that? At the very start of your opening submissions as well as your closing submissions, there should be a roadmap. The roadmap will help guide the tribunal as to the arguments that you will be making. That roadmap will help to provide a PT summary of your main arguments. They should be organized in a logical fashion. Alternative arguments should come after your main arguments. You should always use subheaders or signposts such as first, second, third at the start of the paragraphs of your roadmap. That helps the tribunal to keep track of how many arguments they have to go through. So in the example that we have at hand, you would say the claimant, Mr. Robot's claim is based on good faith, fails for the following 4 reasons: first, second, third, fourth. And the headings throughout your closing submissions and your opening submissions should try to distill each section's content to its most concise expression. They should correspond to the roadmap that you have set out. And as a junior practitioner, it is often your role to format the written submission. So if you use styles in Microsoft Word, you would find that you would then be able to generate a table of content. And the table of contents would actually, in a collapsed format, your headings should be able to make the argument for you. So choose good headings which will grab your reader's attention and that will help to guide you through, guide them through your argument. So an example of a heading that is topical in this case would be, Roman numeral 1, the issue of confidentiality. If you want to be more assertive, you can say, issue 1, Mr. Robot has breached his confidentiality obligations. If you want it to be even more argumentative or adversarial, you can say, Mr. Robot breaches confidentiality obligation because forensic analysis revealed that he downloaded the respondent's confidential information on his personal laptop. So in that way, I've given you 3 examples of how you can frame your heading to grab the attention. The second point really is about persuasion beginning with a powerful beginning. So if you take that maxim and apply it throughout your draft, the main point of each section should be persuasively argued in the initial section, or at least in the initial first 2 sections. You should try to limit each paragraph in your closing or opening written statement to just 1 point. I think there's been adequate research behind this, that readers normally pay more attention to the initial sentence of each paragraph. So it's worth spending enough time to craft the conclusion you want them to reach. Now, if you were to spend the entire paragraph building up to the conclusion, you risk losing the reader's focus and also the main point of the argument. The third trick, I think, is the adage, less is more. I think we've all heard of the saying, if I had more time, I would have written you a shorter letter. Now, never mind who came up with that saying. At the end of the day, we tend to be faced with mountains and mountains of written submissions, and the longer your submission is, the more it tends to lose focus, and long sentences also tend to confuse and confound the reader. So what is too long? Let's break it down. Any sentence that runs on to 3 or 4 lines on a page is considered to be too long. Any sentence that is more than 25 to 30 words is too long. And in some jurisdictions, I know that it's court practice, but any sentence that takes up an entire paragraph is way too long. In your first draft, you should put in everything that you want to say, then go over it again with a fine-tooth comb and delete all the unnecessary words. Let me give you some examples of very overused words that often find their way in written submissions and arbitration. So the first example would be adverbs: undoubtedly, clearly, obviously, overwhelmingly. These sorts of adverbs should be deleted as far as possible. Qualifiers like rather, little, very, any. And the last example would be redundant phrases such as in order to, it should be highlighted that, it is worth noting that. These sorts of preface words should also be avoided. And the next point on less is more is the caution that we should try as much as possible to avoid hyperbolic or pejorative language. Pejorative language should only be used sparingly where the evidence calls for it, and even then you should think twice. Now, we often feel that if we use hyperbolic language and we use exaggerated words, we will persuade the tribunal to our client's side. But very often you would find, and sitting as a tribunal member, that it has the opposite effect. It causes the tribunal to pause and think, and to question the accuracy of that hyperbolic statement. And it also tends to detract from the credibility of the argument that you're making. So stick to the facts, use logic, reason, and authority, legal authorities to argue. The fourth point is that you should write for your audience, and you should know who your audience is. You want your writing to make the audience feel smart, feel intelligent in reaching the same outcome that you want them to reach at the end of your closing submissions. So say, for example, if you're before a tribunal of 3 English lawyers, barristers or solicitors, you need to cite English authorities in order to succeed, but you actually don't need to over-argue points of English law, because doing that, I think, would rather be insulting for them. So in this case, if you're seated before lawyers who know the law of Ruritania, you don't have to go ad nauseum in your closing submissions on what the law is. Your presentation of the facts and law, if done in a logical sequence, in a simple enough manner, should enable the reader to come to the conclusion that your client wants as the most natural consequence. And the fifth and last point is about being professional. Many good written advocacy pieces have actually fallen short because of poor editing. So rule number 1, no typographical or grammatical errors. sloppy editing often detracts from the force of your argument. And the reader cannot help but make the association that, look, the drafting is sloppy. That means the lawyer is sloppy. The lawyer is not exacting enough, and his reading of things, whether the facts and the law, is probably wrong. That, I think, is the kind of sense that the tribunal gets from reading a less than professional piece. So if you take anything away, it is that you should edit again any of your written work. The next point on being professional is what you don't do in words, you don't do in formatting. So you don't exaggerate in words and you don't exaggerate in formatting. So use bold, underline, italics sparingly. Not everything needs to be emphasized and brought to the tribunal's attention. And the last point about being professional is you should be selective in what you cite, in what you quote. An example of this is sometimes junior practitioners feel the need to over-egg the pudding. So for one simple proposition, they put in 5 or 6 different cases. Now, when actually one case would do, the most seminal, the Court of Appeal Authority, the Supreme Court Authority. Now, with this example, with 5 cases, the reader looks at the point you're making and then sees 5 cases, his or her eyes gloss over it and they think, I'm going to read those 5 cases later on. If it's just one case, the tribunal will look at it and say, okay, I might as well turn to that one case right now since it's just one case. So think about the effect that it will have and be professional in editing your submissions. So those are the 5 specific tips that I have for written advocacy. Thank you.
Thank you very much. I think these are very helpful indeed. And I think we are all taking notes. Next, I will hand over to Fan, who is going to give us second presentation on oral advocacy. Fan, now the floor is yours.
Thank you. Thank you. Good evening, everyone. Thanks so much to CIETAC and Young ICCA for having invited me. It is a real pleasure for me to be here and share with you some of my thoughts and comments towards advocacy. So, when we say the word advocacy, what do you think of first? Is it a skill, a way of speaking, or even an art? So what is advocacy? The question actually matters a lot because if you don't know what advocacy is, you'll not know why you need to learn it and how you're going to improve it during the learning. I think Mahesh just mentioned his answer. Here you go, my same answer. So advocacy for me is for persuasion. So we use advocacy to persuade the tribunal to agree with us and to support our argument. So if advocacy is for persuasion, then how should we use advocacy to persuade others? What is the first step? Where to go? Is it that we should practice to improve our eloquency? Or try to learn some fancy words like, may I please the court, Your Honor? Or we're just trying very hard to attend all kinds of moves, to improve our fighting skills. What is it? The answer for me is the first step of advocacy, the first step of persuasion is to persuade yourself. So if I'm going to convince any tribunal of any theory you're going to advocate, you can't successfully persuade anyone until you persuade yourself in the first place. So if you have a very silly theory which you don't believe in, don't try to promote it. No one is going to believe you. You're just wasting your time. Then you may ask, then how should I persuade myself? My answer would be, prepare your own case thoroughly. So in my life, there hasn't been one single case that is entirely in favor of one side. Even unfortunately, you got a weak case, you always can find some good points to argue. So try your very best. Try every possible method to find every possible way to advocate your case and choose the best one. So have faith in your case, have confidence in yourself. If you can do that, actually have done half of the work of a good advocacy. So now, if you have persuaded yourself already, then we will need to move on to persuade others. You need to know a theory called 7% rule. So the 7% rule is developed by Professor Albert Mehrabian, so who is the professor of psychology at the University of California. So what is this 7% rule? So according to professors' research, when people are communicating, only 7% of the information is communicated through spoken words. 38% is transferred through the tone of the voice, and 55% of the information is communicated through body language. This is 7% rule. Of course, there are a lot of controversy over this theory, but people have controversy over everything. We can have a smarter way to understand this rule. So Professor Mehrabian is just saying that the contents of your speech is not the only important thing. Other things could be equally important, like how you dress yourself, how you looked, how you sounded. Manners are equally important. So if you want to be a good advocate, dress yourself like a good advocate. Dress informal. You may say that, oh no, they can't be so. People are not that shallow. Come on, accept the reality. We are all that shallow. Remember that in real reality, in the real life, when you enter into a hearing room, that might be the only chance you see the judge or see the arbitrator in your whole life. So the first impression is very important. So dress yourself like an advocate and behave professionally. Then you may start your advocacy. Here you need to pay attention to two things. First of all, your body language. Sit or stand straight, as the case may be, with open gesture to show that you are ready, you are confident, and you are open to any further discussion. Second, don't speak too fast. So speaking too fast is a very common mistake made by maybe all of the advocates, including me. But study shows the best speed for presentation is between 100 to 150 words per minute. If you're too nervous and try very hard to spit out 200 words a minute, a lot of the meaning cannot be received by the audience. So that means you're wasting your time. So don't speak too fast. Another issue is sometimes, the advocates, they are so nervous. They just keep on talking. And as if they stop talking, their case will die. This is not the case. Try to use pause and silence wisely. So when you pause, what happened? What happened just now? So you pay much more attention to me, right? So if you have something that is really important and you want everyone in that room to hear you about this point, pause until every arbitrator raise their head and look at you, and then you can go on. And under that scenario, everyone hears you. So don't be afraid of pause and silence. Silence is your good friend. So next, the last thing I want to say about advocacy is, what do you think is a key issue of your submission? My own opinion is, actually what I said in the courtroom is not that important. What is really important is the bundle I handed over to the tribunal. Why so? Because when the tribunal renders their award, they can't say that because the counsel says so, so I'd agree with her. No, they will need to refer to the facts or legal authorities that you refer to. So when you do your own submission, try to refer to your bundle and wait until the arbitrator finds the right place. You need to make a beautiful bundle. So what is the beautiful bundle? You need to paginate every piece of paper in your bundle and divide them with the tab so that highlight everything you want the arbitrator to notice, so that arbitrator can easily find what you're talking about. Trust me, the more the arbitrator understands your case, the more likely they're going to support you. So due to the time constraint, I need to stop here. But my last sentence about oral advocacy is, be simple, be straightforward, have confidence in yourself, and sometimes less is more. Thank you.
Thank you very much. I'll be sure to follow your guidance, including persuade yourself. This concludes the presentation session. Rahul, do you want to take over from here?
Sure, thank you, Masaki. And thank you again to our initial presenters. I think you've really laid the scene for both written as well as oral advocacy. We now move on to the second part of our webinar today, which is an actual hearing demonstration. We have two very well-known, very reputed practitioners that will be presenting their opening arguments to you. Representing the claimant, we have Ms. Shalaka Patil, who is currently the principal associate at Cyril Amarchand Mangaldas, a law firm in Mumbai, India. Shalaka practices both international investment arbitration as well as commercial arbitration. She also acts before courts and tribunals in India. We have representing the respondent, Ms. Kate Apostolova, who is a senior associate at Freshfields in Singapore. She too practices international commercial arbitration and investment arbitration, and she has been involved in cases both before the US courts as well as, interestingly, the ICTY and UNCLOS. Thank you both, Kate and Shalaka, for accepting our invitation today. We look forward to hearing from you. For the participants, I mentioned that we had sent the case material on the basis of which Shalaka and Kate will be presenting their arguments. We had sent you that material earlier. Please feel free to refer to that material while you hear their presentations. Both Shalaka and Kate will be presenting their opening arguments to a tribunal composed of Ms. Zhao and Mr. Rai, and we are very grateful to the two of them for agreeing to act as arbitrators in this mock exercise. Thank you, and over to you, Shalaka.
Thank you very much, Rahul. Good evening, everybody. Dear members of the tribunal, counsel for the respondent, and other members gathered here today, I am acting for the claimant, Mr. Martin Robert, in this arbitration between Mr. Robert and Cyborg Tech PLC. In the course of the present opening submissions and through the course of the trial, the claimant will demonstrate that it has made a case to entitle it to the following reliefs. 1, a declaration that the respondent breached the SPA, in particular Article 5, which is the obligation to reach target, and Article 2, which is the respondent's obligation to pay claimant 40 million euro, which is the remaining consideration, as also an obligation to act in good faith. The claimant therefore seeks an award of the remaining consideration of 40 million euro and an award of damages, including moral damages. So with this background, I jump right into my submissions. My first submission is that the respondent breached its obligation under Article 5 to reach target by February 1, 2015, which is a period of 2 years from the closing date mentioned in the SPA, and also failed to act in good faith. Article 5 is an obligation on both parties and does not restrict the claimant to just North America, Africa, and China. Article 5 begins with the words that the respondent and the claimant will cooperate to procure. Therefore, it requires a spirit of cooperation between both parties and reciprocity, which is that the claimant is not going to be in a position to perform unless the respondent cooperates. The claimant is also in a controlling position on the board, as the tribunal will note. Article 5(1)(c) specifically states that in addition to North America, Africa, and China, the claimant is entitled to approach any other jurisdiction as well. And the reason I say this is because the article uses the word including, and I invite the tribunal's attention to that word. I rely on an English Court of Appeals judgment. This isn't a Ruritania law case, but I believe it will be persuasive. The case of Gareth Clark versus the Commissioner, in which the Court of Appeals has held that things not enumerated in an inclusive list can also be referred to and relied upon. So the reason I rely on this case is to argue that the claimant was not restricted to approach the business just to the jurisdictions enumerated in Article 5, but could also approach other jurisdictions such as Australia. The other obligations mentioned in Article 5, which the respondent breached, are one, a requirement to participate in the company's business, and as also to reach a target of 500 million euro per year. It is the claimant's submission that but for the respondent's pattern of obstruction, which I will establish through the course of these opening submissions as well as the trial, the obligations and the target in Article 5 would have been reached. It is my submission that in fact the very basis of the claimant agreeing to enter into this SPA was that there would be the claimant would be entitled to approach other unrestricted markets as well. The claimant would have unrestricted market access. And I say this because there are certain documents which evidence this. I invite the tribunal's attention to the presentation at Exhibit 10, page 20, where Australia at page 20 is clearly shown as one of the markets where Cyborg has an already established relationship with numerous business partners. That is the language used in that at that place in the presentation. Also, Mr. Robot,
Patil,
prior to...
before you proceed, looking at Article 5(1), what is the standard that we are to apply to the obligation to cooperate to procure that Tech and Tech achieve the following goals? I mean, it's a bit of an odd obligation. It's an agreement to cooperate to procure. So what is the standard that is expected of the respondents that you say was breached here in support of your case?
Sure, I will respond to that. I invite the tribunal to read Article 5 along with Article 3. Article 3 suggests that the board is controlled by the respondent because it has 3 directors, and board decisions are made by a simple majority. Therefore, if the claimant is to achieve any business targets as per Article 5, it requires the board's buy-in to those decisions. It is my case that the claimant had approached Australian markets, and in fact, but for the respondent and the board disagreeing with the claimant, the Tech and Tech would have received the business of $1 billion Australian dollars by 2015, and thereafter further business of $3 billion Australian dollars. So the way I would invite the tribunal to read cooperate to procure would be that when business is procured by the claimant, it is the duty and obligation, fiduciary duty to the company of the respondent to ensure that it cooperates and does not act as a hurdle or does not prevent the claimant from in fact obtaining or achieving that target. And I'd just add one more submission in response to this question, which is that it was in fact not in the interest of the respondent to let the claimant achieve this target, because had the target been achieved, the claimant would have been entitled to 40 million euro. And the record establishes that there has been a pattern of obstruction just so that this target is not achieved. So this is how I would read the words cooperate to procure in Article 5. So with that, if I may continue, thank you. So as I was saying, the very basis of the understanding in Article 5 and the fact that the claimant entered into this agreement was that the claimant would be entitled to approach other markets. So if the tribunal will look at the email on at Exhibit 7 at page 12 and 13, the claimant states that it is aware that the respondent wants to approach the North American, African, and Chinese markets. Nevertheless, I do want to confirm that if we decide to pursue this project, my team and I would still be able to reach out to other markets. Ms. Terminator of the respondent agrees with this and says, I completely agree with you, and we should not neglect any option. So it is on the basis of this understanding that the claimant agreed to even sell Tech in Tech to the respondent, because the SPA was entered into after this communication. In fact, as I was saying, there is a deliberate pattern of obstruction on part of the respondent. When the Australian opportunities of 3 companies were achieved by the claimant, where a business which was over and above the target of Article 5 could have been reached, a total of 4 billion Australian dollars, the claimant approached the respondent on May 27th, 2014 and asked for certain documentation ahead of a couple of meetings that were organized on June 1 and 4, 2014. On 28th May 2014, Jennifer, a terminator of the respondent, wrote back to the claimant and said, I'll see what I can do and I'll get back. May 29th, 2014, there is no answer. May 30th, there's no answer. And the claimant writes again, reminding that the documents need to be given. May 31st, there is no answer. On May 31st, the claimant specifically puts the respondent to notice and says, I will not be able to present the best case during these meetings and we will lose the opportunity to extend our business. Could you please get back to me? June 1, there is no answer, and the tribunal should note that the tech solutions opportunity is lost. June 2, June 3, similarly no answer. And then a dejected Martin writes to Jennifer saying that for your lack of support, this case will most likely result in a loss of opportunity. And it did, members of the tribunal, because the opportunity we're speaking of, as I had mentioned, is specified in Exhibit 11, which is an article which notes that FR Tech, a competitor of Tech in Tech, benefited from the withdrawal of Tech in Tech from this business for reasons unknown to anybody. And a business of 1 billion Australian dollars was received by FR Tech. And what is unfortunate is that but for the respondent's breach, a further business of 3 billion Australian dollars could also have been reached, as is clearly noted at that Exhibit 11. In fact, there is also an admission in Ms. Jennifer Terminator's witness statement, where in a response to why this Australian opportunity was prohibited by the board, the only reason and the answer is given is that it is not in line with our initial strategy to focus primarily on North America, Africa, and China. But in fact, I invite the tribunal to note that this is a breach of Article 5 because it specifically requires the party to approach not just these 3 restrictive markets, but any market that may be available. And therefore, for the reasons that I have stated above, I say that the respondent did not act in good faith. And there is duty to act in good faith, which is recognized by various jurisdictions, including civil law jurisdictions, such as the Supreme Court of Estonia, which has, in a number of cases, recognized such a duty. Similarly, principles of international contracts of UNIDROIT also recognize this duty to act in good faith and in the interest of the company. So for this reason, I therefore argue that the claimant is entitled to not just the remaining consideration of 40 million euro, but also to damages. And what are these damages? These will be established, of course, during the course of the trial. But for the purposes of the opening submissions, I argue that these damages are: 1, the profits that Tech in Tech lost and the business Tech in Tech lost, but for the respondent's breach, which is at least 3 billion Australian dollars, and also moral damages, because the claimant in his witness statement clearly notes that he was humiliated by his inexplicable termination by the board without any reasons, illegal termination by the board. And he's a person who is highly established in his field, having received a number of awards and recognition. He is in fact Tech in Tech, and because of this humiliation, he's also entitled to moral damages. I will end my submissions with 2 last points. One would be that I would rely on the case of Porton Capital Technologies versus 3M UK, in which has a very similar fact pattern to the present case, in which there was an earn-out agreement connected with the obligation of the buyer to achieve certain targets in the company that the buyer purchased. And those targets, the court found in that case, were not achieved by the buyer. In fact, they were deliberately breached, as a result of which the earn-out could not be given. The court found that because of this breach, the claimant in that case would be entitled not just to the earn-out, but also to additional damages. And one last point, as I said, I'll make is that a lot of allegations are being made by the respondent today, and rather belatedly, I might add, that confidential information has allegedly been stolen by the claimant. It is my submission that this is incorrect, because claimant did nothing wrong. And the only information that was taken for the purposes of showing the real value of Tech and Tech, which is 100 million euro. And it also, Article 7.3 of the SPA permits this. I thank the members of the tribunal for a patient hearing.
Kate, you have the floor.
Thank you very much. Members of the tribunal, good evening. My name is Kate Apostolova, and I represent the respondent, Cyborg Tech, in these proceedings. As a matter of logistics, we have prepared for you a small binder of core materials, which includes 11 exhibits, and I will refer to those exhibits during my opening arguments, if I may. So my aim today in this opening is to bring this dispute back down to earth. You heard the claimant's counsel tell a very passionate story of humiliation, and a story based almost entirely on the claimant's own testimony. So in contrast, I will try to give you a methodical and accurate narrative of what happened here based on the contemporaneous evidence on the record, on those 11 exhibits that we have put in the binder for you. So to achieve that, my roadmap is to first address the facts, to show you what actually happened, as evident from the contemporaneous documents. I will then turn to why the claimant's claims and his legal arguments must fail. And finally, I will turn to my client's counterclaim for breach of the confidentiality provisions of the SPA. So let me begin with setting out the factual background of the dispute. My client, Cyborg Tech, is a leading multinational defense company. It provides cybersecurity around the world, a critically important service in this day and age. So Cyborg Tech was interested in acquiring the claimant's company, Tech and Tech, to expand its business, and in particular, to expand its services into 3 critical for my client markets: North America, Africa, and China. This was so because Cyborg Tech saw these 3 markets as being the next big thing in cybersecurity, and it wanted its foot in the door. So in November 2012, Cyborg Tech and the claimant started negotiations for this proposed acquisition, and this is when Cyborg Tech made a presentation to the claimant outlining its strategy and its goals. And that presentation is on the record, Exhibit 10, and you will see in that presentation, slide 4, Cyborg Tech stated, there's a specific interest in reaching out to 3 specific markets: North America, Africa, and China, as these are growing markets in the field of cybersecurity. So from the outset, the goal was very specific. After those negotiations, my client and the claimant entered into a share purchase agreement, or the SPA. Under the SPA, the claimant agreed to sell 100% of the shares of Tech and Tech to Cyborg Tech, and my client agreed to pay $100 million, 60 million euros, in cash at closing, and 40 million euros within 2 years, but only if the business achieved very specific targets, agreed in Article 5. And let's look now at the criteria and the targets. And based on the contemporaneous evidence, let's us examine whether the set targets were met or not. If I may direct the tribunal to Exhibit 1, which is the SPA, Article 5, which provides that, as the claimant's counsel properly noted, both the claimant and my client are to cooperate to help Tech and Tech achieve those 5 very specific goals. And in the interest of time and
sorry, counsel, my pause you here. So what do you think is the relationship of Exhibit 10, the PPT or PowerPoint presentation, and the exhibit number 1? What is the relationship between these 2 evidence? Because you mentioned that before you reach the agreement, there is the presentation and set the goal very clearly, and then you said that the parties reach the agreement. So what is the relationship?
The relationship is that in both, during the negotiations and in the SPA, my client's target was very specific, very specific to North America, Africa, and China. So we looked at the presentation, Exhibit 10. If you look at Exhibit 1, which is the SPA, Article 5 expressly says the company's business in North America, Africa, and China are to be included and are to be developed. So the claimant's argument that you just heard, that Article 5 does not restrict the claimant, is beside the point. The respondent's argument is not that Article 5 restricts the claimant to those 3 markets. Article 5 does not restrict the respondent and the claimant in developing those markets. Article 5, though, in combination with the negotiations, requires the claimant to develop the market, the business plan in North America, Africa, and China. And did the claimant do that? No. Let's look at the evidence on that point. In his witness statement, telling me the claimant does not give a single example of any attempt to develop any business plan in North America, Africa, or China. And the fact that he did not make any efforts, in spite of repeated reminders from CIETAC, is also recorded in a contemporaneous letter from CIETAC to the claimant, which is Exhibit 2. So that's one target that was not met under Article 5, not because of my client's fault, but because of the claimant.
Do you at least accept that Article 5(1) entails an obligation to expand the company's business in markets other than North America, Africa, and China? Do you accept that that is the obligation?
I accept that it's not restricted to North America, Africa, and China, yes. So Australia would be one example of where the business can be developed as well. But there must be a clear effort to develop a business plan and business opportunities in North America, Africa, and China. And the claimant did not do so. The claimant wanted to focus on Australia and did not develop the market in either North America or Africa or China. Now, under Article 5B of the SPA, which is the second target, the claimant had to participate in conferences and meetings of relevant importance for the company business. Did the claimant do so? No. Let's look at the contemporaneous evidence on that point again. If you refer back to Exhibit 2, which was the letter from CIETAC to the claimant, it notes that although you had to act as TechNTech spokesperson at major events and conferences, you did not actively get involved in the preparation and execution of any of TechNTech's recent roundtable events. And later today, you will also hear testimony from CIETAC's CEO, who will tell you of the important client meetings which the claimant simply left without providing any explanation whatsoever. And finally, the third target under Article 5C, the claimant had to help the company conclude 10, and I stress that's 10 contracts per year, or 20 contracts for 2 years. Did the claimant do so? No. The claimant did not conclude 20 contracts. You heard just now a lot being made out of one contract in Australia, but importantly, that's one contract, not 20 contracts that are required under the SPA. So for the sake of argument, even assuming that my client withdrew from the bidding process unreasonably in Australia, and even further assuming that TechNTech won that bid, which are two big assumptions, the claimant would still not be in compliance with the SPA. The company would still have not met this one target out of 5 targets that it had to meet. So none of the conditions in Article 5 were really met, and I invite the tribunal to keep this list of targets in your mind today and as you deliberate, because it's an important list, and 2 things flow from failure to meet this target. One is because not meeting the target was a material breach of the claimant's obligations under the SPA, the board terminated the claimant's role as the managing director, and because the targets were not achieved within 2 years, CIETAC is not obligated to make the second payment under the SPA. So these are the relevant and accurate facts. Let me turn briefly to the legal arguments raised by the claimant. The claimant you heard today alleges that we breached our obligations under the SPA to act in good faith and to refrain from abusing our rights. This is simply false. As I established earlier, it's the claimant who did not comply with the targets under the SPA, not CIETAC. We heard today that Article 5 does not restrict the markets to develop to North America, Africa, and China. Again, this is an irrelevant argument. Our argument is not that the claimant was restricted to those markets, but those markets were a clear target, expressly named in the SPA for a reason. It was required that the claimant help develop those markets. You also heard today that the claimant was somehow obstructed from CIETAC's CEO from developing any markets. And again, pointing to an example of the CEO allegedly ignoring his emails, that again is false. If you look at the evidence, you look at Exhibit 8, which is the email chain between the CEO and the claimant, the CEO did respond to the claimant's email, stating she will check what she can do about the claimant's specific request that the CEO send him CIETAC's business plans. So the CEO will explain to you later today that she couldn't simply just send him confidential business plans without having first consulted the other board members. Such an important decision as that of reaching out to a new market requires prior consultation of the board members.
Ms. Apostolova, your time is up. Could you wrap up, please?
Yes, so just turning lastly to our counterclaim. The claimant breached the confidentiality provision. The claimant admits as much in his submissions. It just argues that the breach falls under the due process exception in the SPA, and it simply doesn't. The claimant breached the confidentiality starting in November 2013, before any due process, before any arbitration proceedings were contemplated or initiated. So this argument must fail. And the tribunal should find the claimant breached his obligations under Article 6 and 7 of the SPA and award damages. So in conclusion, we ask the tribunal to dismiss the claimant's claim, to find that the claimant breached his confidentiality obligation, and to award CIETAC damages for the claimant's confidentiality breach. Thank you for your attention.
Thank you very much for those excellent presentations. Thank you also to the tribunal for their interventions. We now turn to the third part of this webinar, which is a question and answer session, which will be moderated by Brad. Brad, the floor is yours.
Thank you, Rahul. Ladies and gents, we have collected 3 types of questions from the audience, including those who subscribed earlier. And they are about opening arguments, closing arguments, and oral pleading in general. And we have selected about 10 questions, and we will ask our speakers to answer them one by one. Let's kick off with opening arguments. And the first question is for Fan. Fan, what are some key topics that should ordinarily only be covered during opening arguments? And is it better to make the opening arguments as comprehensive as possible?
Yes, thank you, Brad. I think that Kate, I really appreciate her demonstration. Actually, she did a very well job regarding a good sample of the opening, statement. So regarding opening statement, you need to know what is the function of the opening statement. That is to set the structure and foundation of the whole case. So there is, what you need to address in the opening statement is, vary from case to case. But for the tribunal to understand the foundation of the case, you must be very accurate and very brief. Don't try to feed in too many details, because you can save the details to later stage when you submit your evidence and legal debates. If I can make a comparison, making an opening statement is like paint a picture. So when you paint a picture, where are you start? Where you start? You said how big is the picture and what is a structure? Like you paint a tree. Where's the root? Where's the trunk? Where's the branches? And where are the leaves? Are you going to paint every leaf in the first place. No, you won't. So opening statement is only to paint the structure so that the tribunal will know what you are going to talk about in the case. And then in later stage, you start to feed in all the details. So don't say too much information in your opening statement. The tribunal will be overwhelmed. They can't understand you fully. So you're wasting your time.
Thank you, Fang. Now the next question is for Kate. Kate, what skills are important to attract tribunal members' attention to your opening arguments?
I think, as it was just said, to be able to paint a picture. I think to be able to tell a story that comes to life for the tribunal. And sometimes it's quite difficult when you have a simple breach of contract and a breach of a share purchase agreement. How do you make it come to life? But I think you just have to try if you want the tribunal's attention. And just the general skills that you need for public speaking, I think, which is try to maintain eye contact with the full tribunal, not just whoever is asking the question. That will increase your credibility with the arbitrators, and it will also make them think that you like them, even if you don't really. But that's important, I think. And also, it will give you a sense of how the arbitrators are reacting to what you're saying. So if you see they're not convinced about a specific point that you're making, maybe focus on that point a bit more and try to convince them to understand your position better. Also speak slowly and clearly. They have to be able to follow you and be passionate about the case. You don't want to bore them to death. And there are a lot of stories about arbitrators falling asleep during arguments. It's not always your fault, so don't take it personally, but try, I think, to do whatever you can not to make them fall asleep. And the style, the body language, those are important, as we already discussed.
Thank you, Kate. Now we move to closing arguments, the questions about closing arguments. And the first question, again, is for Fang and also Shalaka. Fang and Shalaka, let's go with Fang first. Do you recommend preparing closing remarks beforehand or doing so fully up to a few days before delivery?
Yeah, thank you. So I think that many common questions regarding the closing statement, that is some young lawyers, they feel that they can't prepare the closing statement beforehand. But I think that is some kind of misunderstanding, because when you do the closing statement, you still need to know what is the function of the closing statement. That is to summarize the key dispute between the parties. And based on the agreed facts or, still controversial facts, and apply the law to those facts. So to some extent, you can always prepare your closing statement. At least you know what is the key dispute of the parties and what facts the party agree or not agree, and prepare your legal debate. That is why you can't say too much in your opening statement, at least in Chinese legal system, because they have different function. Don't fill in the legal debate in your opening statement. Otherwise, you're self-repeating yourself in the closing statement. So I prefer to prepare, the closing statement 1 day before the hearing, because at that time, I'm fully engaged in the case. I clearly know what the parties are going to debate. So I will summarize the key issues and prepare what I'm going to say. But at the same time, you need to be very flexible, because new things happen during the hearing. The party may agree with something and you did not expect, and the party may, have dispute over new things. So my preference will be you go your rhythm, you state what you prepared in advance. And then you get back to the new things that happened so that you will not, mess up your rhythm of the prepared closing statement. That is my, comments. Thank you.
Thank you, Feng. And Shalaka, what do you think?
Thank you, Feng, and thanks, Brad. My preference actually is to usually prepare the closing arguments and the closing statement after having received the full color of the trial. And as Fang also said, the closing arguments sort of tend to look a lot different from the opening ones, but they do draw from what your opening arguments may set out. And particularly in India, often judges and arbitrators are heavily reliant on what you state in your closing submissions, perhaps even more than what you may argue through the course of the trial. And there are some key elements from the trial, particularly the cross-examination transcript, which will be sort of, or perhaps, admissions that you may get during the cross-examination, which could perhaps be sort of the crown jewel of your closing arguments, and the benefit of which you will receive only at the end of the trial. And in certain jurisdictions, including in India, during the cross-examination, you're also permitted to ask witnesses to produce documents. So sometimes I have seen in matters that through the course of the trial itself, the color of the case changes because of new documents that get introduced. And because of that, like I was saying, your closing arguments and your closing written submissions particularly look quite different from where your case began on day one. Thank you.
Thank you, Shalaka. And the next question is for Mahesh. Mahesh, how do you summarize and highlight your case, especially in a complex dispute? And when, how do you do that when you're making closing arguments?
I think the idea is to develop a case theory from the outset, a theme, if you will, from your opening statement that will run through the way that you present your case, and that will also permeate through how you actually present your closing argument. And if you're talking about oral closing arguments, those are quite rare, to be honest, in international arbitration these days. But if you get a chance to make oral closing submissions, I think the trick is to be very pithy, right? Choose headliner items that would grab the tribunal's attention, and I think that you should focus on the key issues. I think most disputes that we come across, I think we would have, it can be reduced to 4 to 5 issues at the very most, and even that, not really, right? So I think that at the end of the day, you should try to be as concise as possible. You should pick a case theory that would help, that makes sense of the facts and the developments along the way. And I think that would actually be of persuasive value if the tribunal looks at your case theory at the story that you're trying to tell, and that seems to accord with the contemporaneous evidence. Then I think your argument will win the day.
Thank you, Mahesh. And for the benefit, for the interest of time, let's move to the last question, which is quite related to the CIETAC Cup. The question is open floor for every speaker this evening or morning. And the question is, do you think that participating in moot competitions would assist in improving oral pleading skills? And I'll leave the floor open. Mahesh, do you like to start first?
I think for younger practitioners, it's always a challenge to get to the mic, because when you start out especially in large practices, you're often 4th or even 5th chair, and then you slowly rise through the ranks, and you can spend a long time as 2nd chair before you actually take to the mic. So I think that moot competitions are an opportunity for lawyers to try to hone their advocacy. I think by now all of us have heard of the 10,000 hour rule. So how do you get good at something without practice? And so oral advocacy is normally honed through moot competitions, through even presentation in front of your clients, or if you're so lucky and somebody decides to throw you a bone, cross-examination of a minor witness. So take whatever opportunity you can. These days, there are even competitions for lawyers, for young lawyers. So I think they definitely do help to, I wouldn't say they help to simulate what happens in real life always, but it helps you to develop your own style and to become comfortable in presenting a case.
Thank you, Mahesh. Anyone else?
Yes.
I think Mahesh, sorry, Fan, please, yes.
Yes, I think I'll say something very encouraging because I also, of course, I'd agree with Mahesh that if you have any opportunity to participate in the moot, please go ahead, because as Mahesh said, you will need, several years until you reach the mic and be the chief advocate. But before that, you need to try. But if you do not prefer to participate, don't worry. So the first moot I personally attend was the one in last year when I lead my firm to participate in the demonstration of, international arbitration in Chinese. So that is the very first time I attend a moot. So you don't need a moot to be a good advocate. So don't worry if you are not a fan of the moot. That's all.
Thank you. Now, Rahul, I'll leave the floor to you for the closing. Thank you very much, dear speakers. Thank you.
Thank you very much, Brad. Thank you, Theomonique Notage, excuse me, our Young ICCA co-chair, unfortunately, has faced a power outage, leaving it to me to deliver the closing remarks. Fortunately, it's one of the easiest things to do. So I just start by saying thank you to the panelists for their excellent presentations. We've learned a lot, I think, over the course of the past hour. Mahesh's advice: be clear, be structured, less is more. Don't have 15 authorities in support of one point. One is sufficient, and that one will be read. I think that's very topical and very important. Ms. Zhao's point: convince yourself first. And always keep in mind the 7% rule. I think that's also incredibly important, and it's very accurate. We then had really excellent presentations by both Ms. Patil and Ms. Apostolova, and it's a good exposition of different advocacy styles in action. I don't think that there is really a correct advocacy style. Everyone has their own style. It's just a question of how you meet those essential elements that both Ms. Zhao and Mr. Rai stated in their opening presentations. So thank you very much to the panelists for all of your presentations. Thank you also to the participants for your patience throughout this entire exercise. We hope that you found it useful. I also would like to thank Masaki for his excellent organization of this webinar. He's really been principally responsible for putting it together. Thank you very much, Masaki. Thank you also to Brad and the rest of the CIETAC representatives. Your contribution to us in putting this together has been absolutely invaluable. The event, this webinar, will be recorded, is being recorded. A copy of that recording will be made available on the Young ICCA website, so you can easily view that. We will also prepare a written report of this webinar, and you can have a look at that written report as well. Everything will be uploaded on the Young ICCA website. On the Young ICCA website, you will also find a list of our future events. We do have several interesting things coming up. We encourage you to join us there. And that's all for me. Thank you very much once again, all of you.